Gentleman from Kansas to lead us in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, gentlemen. Pursuant to notice, I call up H.R. 59, the Mens Rea Reform Act of 2025, for purpose of a markup, and move the committee reported favorably to the House. The clerk will report the bill.
H.R. 59.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Arizona, Mr. Biggs, for an opening statement.
Thank you, Mr. Chairman, and I appreciate you bringing this bill forward today. In 2010, the Heritage Foundation and the National Association of Criminal Defense Lawyers published a report titled, "Without Intent, How Congress is Eroding the Criminal Intent Requirement in Federal Law." And I would ask for unanimous consent. That'd be
without objection.
Thank you. The report authors analyzed 446 nonviolent criminal offenses proposed in the 109th Congress, and they found that 50% of the analyzed offenses lacked adequate mens rea provisions. In 2021, they followed it up, same group, National Association of Criminal Defense Lawyers and the Heritage Foundation, and they found that the trend continues. And only thing different being that maybe even more bills are being passed without adequate mens rea requirements. Just a couple of weeks ago, we had a hearing, and the witness brought in by the Democrats in his opening statement advocated for the passage of this bill, H.R. 59, and also mentioned the following bill that we'll do also favorably. What I'm suggesting to you is this should be a bipartisan approach to this bill today. I'm looking for that. I believe that we should do that because there is so many issues here. So when you begin to compare John Carlo Canaparo during the hearing, who was comparing federal crimes that are morally wrong and the federal offenses that are regulatory in nature, he cited some bizarre examples, such as the prohibition on selling Swiss cheese without holes, the requirement for certain toy balls to carry specific warnings, and the estimate is that there's more than 5,000 of those types of crimes, except for when you get into the rule process, the bureaucratic crime-making process, you'll find that there are hundreds of thousands of those, and they don't have mens rea requirements. I'll give you a couple cases. The one that really sings to me is the Gibson Guitar Corporation's factories in Nashville and Memphis. They bring in exotic woods, computers, guitars. Everything was seized under the allegation that they had violated the Lacey Act because they imported rosewood and ebony that was not harvested or exported in compliance with Indian and Malagasy law. But the Lacey Act makes it a federal crime to import wildlife or plants taken or traded in violation of any foreign law, but the relevant foreign laws were not clear, not publicly available, not consistently enforced by their own federal governments, and indeed the statute did not require the importer knowingly or have any culpable mental state to violate the law. So ultimately, they were imposing or seeking to impose, the feds were, criminal liability without any knowledge or intent on the part of the actor. That is against the longstanding Anglo-Saxon historic history of the jurisprudence that we have. There are other cases. We have the individual a case highlighted by the Democrats' witness, Mike Fox, and this is the case of Michelino Sunseri, who is a professional trail runner, and he was charged with a federal misdemeanor by the National Park Service for running on a trail that was allegedly closed, despite the fact that the trail had been used without incident for more than 50 years and did not have any signage indicating its closure. Again, there was no culpable mental state. There was no way for him to know, and nor was there ostensibly a requirement for a culpable mental state. But the Mens Rea Reform Act directly addresses these concerns by creating a default knowingly standard for federal crimes lacking explicit mens rea requirements. By restoring the essential element of criminal law, the culpable mental state, Congress can help ensure that only those who act with intent or knowledge are subjected to the penalties of the criminal justice system which is fair. It reinforces civil liberties, and it curbs prosecutorial overreach. And that's the purpose of this bill. And Mr. Chairman, I thank you for bringing it forward, and I encourage everyone from both sides of the aisle to vote aye in favor of this. Let's move this along today. Thank you, Mr. Chairman.
The gentleman yields back. Chair recognizes the ranking member, Mr. Raskin, for an opening statement.
Mr. Chairman, thank you very much, and thanks for calling a hearing, a markup session on these bills. And I thank the distinguished gentleman from Arizona for his remarks on it. I'm delighted that we're taking up the whole question of over-criminalization, which is indeed a serious matter for the people of the country. Just as the people can obviously suffer from there being too many crimes taking place in society, we also can suffer from there being too many criminal laws in the country. Everybody knows the basic legal dictum that ignorance of the law is no excuse. That's not going to get you out of prosecution for an offense that you didn't know about it. On the other hand, if we have tens of thousands of laws, nobody can know what all of the laws are. And so it is essential to a society based on ordered liberty and the rule of law that people have the chance to know what the laws are. Unfortunately, we have a couple of bills we're bringing forward today, including this one, the Mens Rea Reform Act and the End Endless Criminal Statutes Act, which put the cart before the horse, or put two carts before the horse. The horse is the one that we all agree on, the Count the Crimes Act, being done on a bipartisan basis by Mr. Roy and by Ms. McBath. Let's determine what the problem is. What's the scope of the problem? What are all of the criminal laws that are out there? It's remarkable that we have no inventory. We have no basic understanding of what all of them are. Now, in a bunch of those, I would agree with the gentleman from Arizona that we should alter the mens rea to make sure that there is a knowledge level of culpability there. In others, that would undermine the law and undermine public safety if we were to do that. And that's why we need to put them all together to figure out what is actually the landscape we're dealing with. Unfortunately, I'm going to oppose this law. It is, or this bill. It's premature to bring it forward right now. And in fact, in a number of fields, we need stronger anti-corruption laws and anti-fraud laws as we're living through a period of tremendous corruption and fraud and scams that are taking place against our people. And we would want to scrutinize very carefully what the abolition of the mens rea or the current culpability standards would mean, and to replace it with a higher level of culpability with a knowing level of mens rea. But we've seen a weakening of the laws against fraud and corruption, and we should be moving in that direction. 15 years ago, the Supreme Court overturned the conviction of Jeffrey Skilling, the Enron CEO, whose massive fraud and conspiracy scheme wiped out billions of dollars in employees' retirement savings and shareholder equity. 4 years later, the Supreme Court threw out Governor Bob McDonnell's conviction in Virginia on bribery charges stemming from favors that he did for Virginia businessmen who lavished him with $175,000 in gifts and cash and loans. And the court did that by making it more difficult to prove that a quid pro quo had taken place. And just last year, the court tossed out the conviction of James Snyder, an Indiana mayor who steered $1 million in city contracts to a trucking company that paid him $13,000 in kickbacks. These are just a few examples of the kinds of gaps in the anti-fraud and anti-corruption toolbox we really should be fixing at a time when criminal prosecutions of white-collar crimes have been declining for decades. So if we were to just pass the Mens Rea Reform Act, it would make these problems worse. It would exacerbate the ability of people to be getting away with white-collar crimes like criminal fraud and tax evasion, kickbacks, and other kinds of corruption. So we think this is too early to be doing this. I look forward to working with the gentleman on reform of culpability standards in a far more targeted and selective way moving forward in the future. And let's definitely go ahead and pass the Count the Crimes Act so we can get a real sense of what is out there. And with that, I urge my colleagues to oppose the bill, and I yield back to you, Mr. Chairman.
I think the gentleman is back without objection. All other opening statements will be included in the record. The chair now recognizes the gentleman from Arizona to offer an amendment in the nature of a substitute.
Yes, I make the motion too.
Gentleman has an amendment at the desk. The clerk will report the amendment.
Amendment in the nature of a
Without
substitute.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for the purposes of amendment. The chair now recognizes the gentleman from Arizona to explain the amendment.
Mr. Chairman, this is just have a couple technical corrections in it. Otherwise, it echoes the underlying bill.
Anyone seek recognition? Gentlelady from Georgia is recognized.
Thank you, Mr. Chair.
You bet.
Our criminal justice system is meant to prevent us from harm and to keep our country safe by creating a system to hold any wrongdoers accountable for their actions. Our system relies on the numerous laws that we already have in place, laws that need to be updated and they need to be clarified to ensure that justice is carried out properly. That is why I am proud to co-lead the bipartisan Count the Crimes to Cut Act of 2025, which would aid Congress in getting the data that we need to determine the exact number of federal crimes on the books and help us to better identify places where we might eliminate crimes that no longer make sense so that we can make sure our criminal justice system is focused on what really matters. Beyond just identifying the number of crimes, the Count the Crimes to Cut Act directs the Attorney General to include in the report the mens rea requirement of all federal crimes, which sets the required mental state that a person must have to be considered guilty of the alleged crime. Yet before we can even receive that full accounting, my colleagues across the aisle want to pass the Mens Rea Reform Act simultaneously, which would establish a default mens rea standard of knowingly for federal criminal statutory and regulatory offenses that lack an explicit mens rea standard. Under this standard, prosecutors would have to prove that defendants knew or did not willingly turn a blind eye to the facts that constitute their offense. So what does this mean in practice? Rather than relying on precise data to determine where reforms are actually needed, this proposal would make radical changes to existing law and threaten to undermine the ability of the government to prosecute a range of crimes, putting public health, safety, and the environment at risk. For example, at a time when the current administration is suspending key quality control programs and purging staff who run our country's health and safety programs, the Mens Rea Reform Act could also jeopardize holding bad actors accountable who put harmful products out in the marketplace. Take the CEO of the Peanut Corporation of America, who was sentenced to 28 years in prison in 2015 after more than 700 cases of salmonella poisoning, which resulted in 9 deaths. They were traced to one of his factories in my home state of Georgia. If the proposed mens rea standard applied to conspiracy, one of the charges that the CEO and his fellow executive were convicted of, prosecutors would have had to prove both that the officials worked together to ship tainted peanut products and that they understood that such action constituted an illegal conspiracy to convict on that charge. Taking actions that result in shipping tainted food that kills people may no longer be enough to convict those who are responsible for conspiracy. Beyond the default mens rea standard, the bill could also change existing standards in the law. And of course, this has to be viewed in the context of President Trump's rampant efforts to let white-collar criminals off the hook, from deprioritizing white-collar prosecutions to gutting the Department of Justice anti-corruption unit, to pardoning those most loyal to him who had already been convicted, while ensuring those individuals don't have to pay a dime to those that they have harmed. Passage of the Mens Rea Act would allow Trump to achieve his goal of throwing white-collar prosecutions down the drain more effectively. It would not help those who are most affected by this country's overcriminalization. While I agree we should have a robust conversation about strengthening mens rea requirements in our federal criminal statutes, let's not put the cart before the horse. I look forward to joining my colleagues in getting the Count the Crimes to Cut Act to the President's desk so that we can identify which laws actually need mens rea reform. Thank you, and I yield back.
Gentlelady yields back. Who seeks recognition? Gentleman from Arizona is recognized.
Thank you, Mr. Chairman. I am intrigued to hear that the argument is not that we should not fix mens rea, but that we should first count the crimes. Count the crimes, they say. I find it intriguing because their own witness 2 weeks ago said, we need to pass this bill, H.R. 59. Their own witness, wasn't me. Well, I was advocating it, but their witness said it, yeah. And the McDonald case, that wasn't some kind of split along ideological grounds. That was an 8-0 decision. That was an 8-0 decision. And I will say the gentlelady from Georgia actually said this correctly. She said this bill will fix those crimes that lack an explicit mens rea. That's right. And how many of those are there? Hundreds of thousands. There are more than 5,000 federal crime statutes.
Right, that's
but there are over 300,000, and the CRS, when we've inquired multiple times, said we cannot even count the number of regulatory crimes. So while you're busy counting them, how many years will go by with no mens rea? I want you to think about what that means. That means effectively strict liability then. That's what you're defaulting to in the American criminal system, the federal level. We're going to default to strict liability because we have no idea what these mens rea are. And what our bill does, what this bill does, is this corrects that. Nothing should tilt the playing field in favor of the prosecution. That is antithetical to the American system of jurisprudence and criminal law. You are innocent until proven guilty. And the very idea that you're going to default to a strict liability standard is absolutely, it's outrageous, quite frankly. Outrageous. Because the bottom line is, you need to actually, in most cases, have some kind of mental culpability. It might be criminally negligent, maybe it's recklessness, but most often it's going to be knowing. Most often it's going to be knowing. That's why the states, which is almost every state that adopted the Uniform Criminal Code 30, 40 years ago, that's why they had the 4 culpable mental states in there. Because that is the burden of the prosecution in those acts. So you get the actus reus, then you get the mens rea. So while you're counting the laws, how many people will be prosecuted effectively on strict liability when the mens rea, the appropriate mens rea, would be knowing? And I did get a kick out of this one, that if you insert a culpable mental state into a federal crime, that somehow that's exacerbating the problem. I mean, how so? How so? That the state would have the burden, the ungodly burden of saying this person knew that the path that they're running on was a closed path, and so we can charge them with a crime. Even though we didn't ever have it marked, and we had a path there that had been used for 50 years. That's the kind of stuff where you go, what are you thinking? Truly, what are you thinking? This is the American jurisprudential way of holding people accountable for criminal culpability. And that typically is you got to prove the actus reus, you got to prove the culpable mental state. Everybody knows when you're prosecuting a case, you're counting the elements, you're looking at every element of the crime, and you're going to prove every element of the crime, and you're going to do it systematically. That's what you do. But here, we're saying, what the Democrats are saying today is, well, we think what should happen, there's literally hundreds of thousands of crimes with no mens rea in it. So what we want to do is count those first. And in the years intervening while they're counting those, then we're going to say, well, too bad if we're going to apply effectively a strict liability type of analysis to it. Because all they're going to look at is the actus reus, and that's a problem. That's why you should pass this bill, and I yield.
Mr. Chairman?
Gentleman yields.
Chairman.
Gentlelady from California is recognized.
I'd just like to say, I understand the gentleman from passion, but I think Ms. McBath has laid out a thoughtful and orderly way to accomplish our mutual goals in a way that will be successful. And I think her presentation was very orderly and persuasive. And I would like to yield to the ranking member, Mr. Raskin.
I thank the gentlelady from California. The gentleman from Arizona has invoked our witness on his behalf, so I want to invoke his witness on our behalf, because his witness, Mr. Giancarlo Canaparo, said the first step towards solving this problem is to gain a clear sense of its magnitude. And he argues precisely for the Count the Crimes Act. I think maybe we're overstating the disagreement between us. The vast majority of offenses already have the mens rea requirement that the gentleman from Arizona and I concur should be the basis for federal criminal law. But for the young people present today, and there seem to be a lot of them, Mr. Chairman, their eyes seem to be glazing over. This is actually kind of an interesting thing we're talking about here. And so let me try to revive my role as a law professor for 1 second. The criminal laws have what's called a standard of culpability. What does the prosecution have to prove in order to show beyond a reasonable doubt that a person's guilty? And for most of our crimes, it's already the rule that you have to show that the person acted willfully or knowingly. They knew what they were doing they acted knowingly with respect to every material element of the offense, or they acted purposefully, deliberately with respect to every part of the offense. But there are certain crimes that have negligence or strict liability as a standard, okay? And we don't even know what all of those are. That's why we want to count the crimes, to round them all up so we don't, engage in an exercise of pin the tail on the donkey where we're blindfolded and we're just saying, well, let's assign this level of culpability to particular offenses without knowing it. Well, what are some of the strict liability offenses? Well, one of them is selling alcohol to minors. If a bar or a tavern is accused of selling alcohol to minors, they can't say, oh, I didn't know that that person was really 17. But that is the law, and that's a policy choice that's been made. And so there are policy choices that have been made like that. Statutory rape is another one. It doesn't, if you have sex with a 15 or 16-year-old, it does not have to be proven that you knew the person was 15 or 16. The burden is on you to determine it. That's a policy decision. You might disagree with that, Mr. Biggs, but that was a policy decision made by the legislature. So I don't think we just want to say we are going to, with a broad brush, go out and overturn the level of culpability that has been assigned by prior legislatures to particular criminal offenses without looking at what they are and what that would mean. Possession of narcotics is another one. Certain environmental crimes are strict liability offenses. You can't say, well, I didn't know what the precise mixture of that toxic waste sludge was that I dumped into the lake or dumped into the land. You're strictly liable for it. That might be the right policy choice, it might be the wrong policy choice, but that's a policy decision. And now the suggestion is, before even creating an inventory of all of these criminal offenses, we're just going to overturn what the existing level of culpability is built into the statute. And that's just a very, I think a reckless way to go from a legislative perspective. Let's inventory what all the crimes are. Let's count them up. Let's get them in front of us, and then we can go one by one and act like legislators and say, yeah, we should go with the basic willfulness standard for mens rea, or there's a reason to keep a strict liability standard. But I, for one, am not willing just to cast one vote and overturn the level of culpability and the handiwork of prior Congresses and just saying, we're going to go to this one particular.
Will the gentleman yield?
It's actually my time, and I wanted to yield to the gentlelady from Georgia, wanted just a final statement.
And thank you very much. And actually, if you take a look, it's actually, the investigation is only for 1 year's time. Just 1 year's time. So you're not talking about an extended period of time. You're talking about 1 year's time to do the work that we need to do before we move forward.
I yield back.
Gentlelady yields back. Gentleman from Texas is recognized.
I thank the chairman, and I appreciate that we are here, I think, with at least some bipartisan agreement on the extent to which we have an over-criminalized federal government and an over-criminalization generally, and that we need to review that and look at that. Now let's talk about the Count the Crimes Act. This is legislation that I introduced, I think 5 years ago, something like that, along with the current minority leader, Hakeem Jeffries, who once served on this committee. I'm delighted to now have the legislation with the gentlelady from Georgia, and we are in agreement on, I think, the goals of that legislation. And I do think it's important, but it will take time, significant time. And in fact, I'm concerned that notwithstanding our passing the act, which I hope we will do out of committee today and from the floor forthwith, and hopefully the Senate will move it, previous efforts to count the crimes have failed miserably because there are so many of them. And because it is so difficult to wrap your arms around 5,500 crimes of varying natures and 300,000 pages of criminal codes and regulations that have now criminalized every act that you can possibly imagine for the American people. And I think the issue here, that why I support, of course, the Count the Crimes legislation, but also the gentleman from Arizona's legislation on mens rea, is this is not a new issue. This is an issue that has been around for decades. There was committees that were formed in the 1970s to look at this. There have been bipartisan efforts over time with people ranging the ideological spectrum because of the importance of mens rea. Now, why does mens rea matter? Because you ought to know, you ought to have to know the crime, you ought to have intent, you ought to have knowingly committed the crime, the various things that we have put in the elements of various statutes, but not always. And that's the issue. Right? And so what this is attempting to do is say, okay, there are in fact many statutes, including, by the way, a lot of the white collar crimes that the gentleman has alluded to. For example, the Clean Water Act, which has language in there like knowingly. And my concern here is that we have significant statutes and regulations that do not have that clarity. And the gentleman from Arizona, I think, is rightly trying to put the clarity in there. For example, and I'd like to insert in the record without objection, or ask unanimous consent, I should say, to put in the record a report from the Right on Crime organization. Congress needs to make up its mind, mens rea reform and why it matters. So I'd ask consent to do that.
Without objection.
And one of the things that they note in here is that criminal penalties were historically imposed for inherently immoral acts, such as murder, arson, rape, immorality, some could say. Can largely mimic rules to protect public safety. But nowadays, criminal penalties attach to a wide range of actions. Take, for example, 18 U.S.C. 336, which makes it a federal misdemeanor to write a check for less than a sum of $1. Like, that's absurd. I mean, I'm sure some of the folks in the audience don't even know what a check is, but the fact is that's absurd to write a check for less than $1 is a federal offense, right? So you say, all right, well, do you know that? Someone's out there and writes the check for 80 cents and somehow you've violated federal crime. Or consider how a 1-year penalty and penalty and monetary fine could apply if someone allows his cattle, horses, hogs, or other livestock on federal land for the purposes of destroying the grass or trees. Also, for the purposes of destroying the grass or trees. These laws are concerning because they make Americans felons for nonviolent, innocuous behavior. So these are the kinds of things that I think that we're trying to address. The mens rea element is important, and I think that it's critically important that we have it without waiting to count the crimes. With that, I don't know if the gentleman.
Would the gentleman yield for a question?
Well, the gentleman from Arizona one at a time, with respect to the ranking member.
Yeah, so thanks for yielding. I just want to clarify that in the bill itself, it says any element for which the text of the covered offense makes clear that Congress affirmatively intended not to require the government to prove any state of mind with respect to such element exempts you from the bill. So maybe that should alleviate some of your concern. And then when you get to our witness that you were asserting that he wanted us to count the crimes first, let me read directly from his testimony. So where do we go from here? For years now, my colleagues and I have asked the federal government to count, review, and cut the excess federal crimes in both the U.S. Code and in the CFR. Likewise, we have asked the government to adopt a default mens rea law that would apply some default intent requirement to any federal crime that lacks one. That's what this bill does. It's consistent with what the National Association of Criminal Defense Lawyers wants, what your witness wanted, what our witness wanted, and now we find you guys kind of changing your tune. Yield back.
I yield back.
Who else seeks recognition? Mr. Raskin, you seek recognition?
Thank you, Mr. Issa. Yeah, if I understood my friend from Texas correctly, he was basically saying that the job of counting the crimes is literally impossible because it's countless or it's infinite and it'll take forever. But I understand.
I didn't say impossible. I just said difficult and will take some time.
But the legislation calls for the count within 1 year.
I get that.
And
I hope it's successful.
Yeah. I mean, I think we're very close on this, but I think that, to me, it feels a little bit like legislating in the dark to say we're going to go ahead and alter the level of culpability assigned to every criminal statute without even knowing which ones we're talking about.
Would the gentleman yield? I know, and I would have liked to have yielded before, but I'd already agreed to yield to the sponsor.
Yeah.
To the gentleman, because I think we're largely in agreement here. This is not a partisan issue, right? So, I understand the gentleman's concern, but can we just level set on the concerns? Do we not agree that the legislation specifically exempts laws that already have mens rea or have specifically said that we needn't have it?
Would you show me that part? Can we look at that?
I will defer to the sponsor.
Page 5, lines 1 through 8.
Would the timekeeper please suspend the time for a moment?
Yeah, it makes clear the.
And it's the ranking member's time. I've yielded back to him. Yeah.
So, the prior language says at the bottom of 4 shall not apply with respect to any element for which the text of the covered offense makes clear that Congress affirmatively intended not to require the government to prove any state of mind with respect to such element.
And if the gentleman doesn't think that suffices, then we could try to modify that. But I would think that I read it as sufficing.
Well, what if the Congress affirmatively intended for the government to prove negligence? In other words, negligence is a lower standard of culpability than willfulness, but it's higher than strict liability. So that seems to slip out of there, right? And that there are.
Would you yield for just a question?
Yes.
Would it not then specifically say in the text negligently and thus be this language would be otherwise sufficient?
Well, but that's what I just don't know. I'm not, because negligence is not not acting reasonably. So that's not exactly a state of mind. So yeah.
But as the law professor, when you're teaching the criminal code, for instance, in Maryland, which is very similar to Arizona because they've adopted the Uniform Criminal Code, you're teaching 4 different culpable mental states. That's specific to every state code, and one of those is criminal negligence. One of them is recklessness.
Yes.
One is knowing, and one is intent. So yeah, you're dealing with those culpable mental states, but you're also not talking about strict liability too much because a strict liability statute typically will say it's a strict liability. It will have indicia in it, just like it would on recklessness.
I guess my question for you is negligence a state of mind or is it not a state of mind within the terms of this legislation?
I think that case law is pretty clear that it's treated as a state of mind.
Okay. I guess this is what makes me nervous just about legislating in advance with respect to a number of statutes. And I do want to point out to my friend, this is a minority of statutes. The vast majority of them either have a defined willfulness standard or that's imputed by the courts. So we're talking that it should not be that hard to count these up and look at them, and then we can make a specific judgment about whether negligence or strict liability or some other standard is appropriate.
Just two quick points. An example of this would be 18 USC 1115, which talks specifically of, say, misconduct or negligence. It says it in there, but that's the statutory. So when you reference and you say, it shouldn't be that hard, ask Congressional Service, CRS, ask them, why don't you, how many statutory vis-a-vis regulatory crimes there are. And they told us multiple times when we asked, there's more than 300,000. They have no idea how many there are. And that means that to count them within a year, for a year, you're not going to have you won't have a mens rea status in most of those, number one. Number two, when you don't get them all counted within a year, what happens then? You got to keep doing it that way and still go without a mens rea requirement that basically everybody who practices in this area has said you need a mens rea standard.
Well, but I guess my response
I'm
is
asking unanimous consent. The gentleman have an additional 1 minute without objection.
Thank you, Mr. Chairman. Look, I think we should give it a try. And we should see if we can actually inventory the statutes so we can look at them to see what we're talking about. Because otherwise, to me, it feels like we're legislating in the dark. It's like we've turned the lights off and then we just say, let's change the culpability standard for all these statutes. We don't even know how many there are or what fields they're in. And we'll do that. And as you know, even the question of legislative intent can be indeterminate and inscrutable sometimes. So even trying to interpret what Congress was thinking may be difficult. And I'm not even clear from this language whether negligence is something that we would hold harmless and free from this process or we would incorporate into it. So again, I don't think we're that far away, and I think we can get this done in this Congress. But, you know, for me, I just don't feel sufficient clarity as to what we're doing. We're saying it's a job so mammoth that we can't even count these laws, and yet then we want to go ahead and legislate with respect to them without studying, you know, the particular dynamics of that legislation. Thank you, Mr. Chairman.
The gentleman yields back. Who else seeks recognition? Gentleman from Kansas.
Thank you, Mr. Chairman. I've been listening carefully to this, and it's a bit of a sense of deja vu for me. And I think it was 2009 or 2010, we recodified our criminal code in the state of Kansas. I was in the state Senate then, and we went through exactly this discussion. Actually, if my memory's right, I think I was the only no vote on recodifying, but it wasn't because of this issue. It had other issues. And I guess I'm a little bit puzzled by the discussion, and maybe I would ask the gentleman from Arizona or from Maryland to help me understand where I'm missing the point here. I'm looking at the amendment in the nature of a substitute, and I'm looking at the top of page 3, lines 1 through 5, which defines the term state of mind and sets out 7 specific states of mind. We have 4 in Kansas, consistent with what the gentleman from Arizona suggested, one of which is negligently. And then I'm looking at the bottom of that page, lines 23, 24, and then the next page, the completion of that paragraph, which I think is the heart of the bill. It sets out a default rule, as I understand the gentleman from Arizona, the gentleman from Texas, that if there isn't a state of mind expressed by the creator of the statute, then the default is knowingly. We could change that for any statute we wanted, but it sets out a default. And I guess my question for the gentleman from Arizona, and this is where I'm puzzled, isn't it the case now that if there is no state of mind expressed in the statute or in the rule or in whatever it is that's being alleged to have been violated, somebody has to fill in the blank on what state of mind applies? and that often occurs in the course of litigation about enforcement or otherwise. And isn't it the case that all this does is have Congress express that if we haven't otherwise expressed a state of mind, the courts are supposed to default to knowingly unless and until we specify otherwise? Isn't that all this bill does? And
if you'll yield.
please.
That is the intent. And I think that's the way it's written, and I think that's what it is. If there is a lack of expression in the statutory or regulatory scheme with regard to that crime as to what the culpable mental state's going to be, which we iterate in here, which is consistent with the federal laws, is a little bit odd compared to the state laws, but yeah, then you're going to default to knowingly. Because as Mr. Giancarlo said, he said, if the criminal law extends to accidental violations of arcane policy rules, the person probably doesn't know that they're in violation of the crime. And thus, the old axiom, ignorance of the law is no defense, goes down the toilet. And he didn't say down the toilet, that's me saying. But the point is, yeah, that's why it's there. And you're exactly right, that's the nub of it.
So, Mr. Chairman, reclaiming my time, just to be sure I understand for the gentleman from Arizona. So in the event we had a current law crime, say an environmental crime, which is the classic example here, that is strict liability, and if Congress has said this is a strict liability crime, nothing in this bill changes that. Isn't that correct? And I would yield to the gentleman.
That's correct.
Okay. Thank you, Mr. Chairman. And
Would the gentleman yield?
absolutely.
For the ranking member as he goes through this, is it really just that you need further clarification of, you're not objecting to the default, but you're objecting to a basis under which it would be considered absent?
Yeah, thank you. And to go to the gentleman's question, I understood the current rule to be that the courts will say, if there's silence in the statute, that willfulness is the general standard now, so that knowledge or deliberate purposeful action are already required. I understood the purpose of this bill to basically take away from the court the ability to determine whether there was legislative intent to the contrary, because it's a regulatory statute, an environmental statute, or what have you. And so we would run over the normal rules of judicial interpretation and statutory construction that a court would be deploying. And that's why I think we should look more specifically at what the statutes are. I believe if all the legislation is intended to do is what the gentleman from Arizona said, I think that's already the law. That is, courts will say, if there's no telling what it is, then given the doctrine of lenity and due process, it must be shown that the person acted with specific intent, with at least knowledge, with respect to every element of the offense. And what makes me nervous is just that there are lots of different elements in any particular offense. Take, environmental offense like dumping in a river. Are we saying there's got to be knowledge that what you put in was toxic? Do you have to show that there was knowledge that this was a waterway covered by federal law? Does there need to be knowledge that the effect of this would be a harm to the public health? Which elements of the offense does the level of culpability carry over to? And I just feel like we're making one big decision for every statute right now without even looking at how it would affect particular laws.
I thank the gentleman. Now recognize the gentleman from Georgia.
Thank you, Mr. Chairman. I rise in opposition to this bill. Let's not get caught up in the weeds on this. There is a lot of verbiage in the legislation that can be confusing, particularly to lay people. But what doesn't confuse lay people is the time that we're living in. The time that we're living in now, and why this legislation would come forward during this time, a time of unprecedented corruption at the top levels of government. and at a time where Congress has shirked its responsibility to be a check and balance on the executive branch, and instead is simply a rubber stamp to an authoritarian. And this authoritarian with a playbook, Project 2025, knows exactly what he wants from Congress, and Congress so far has been pretty complicit in carrying out his bidding. And as a former criminal defense attorney, I might seem like an easy yes on this bill, but this bill is not about giving everyone a fair shot in the justice system. No, this bill is about aiding the Trump administration's continued efforts to let white-collar criminals off the hook. And by the way, I'd be remiss for not pointing out the lawlessness of this president when the first day he's in office, he grants pardons and clemency to 1,600 plus January 6 insurrectionists without regard to culpability, without regard to knowledge and intent. He just did that and has continued to do it throughout his reign so far. Trump's Department of Justice has also gutted the top anti-corruption unit in the Department of Justice. They've removed its power to charge politicians and public officials for bribery and extortion, and reduced its staff from 30 attorneys down to 5. And I would also be remiss if I were not to point out the fact that this administration, which leads this Congress, also let a criminal defendant off the hook for a promise to open up Rikers Island, to carry out deportations, the mass deportation movement. Just closed down that case just for that purpose. A lawless administration. The Trump administration also disbanded anti-corruption task forces, suspended any investigations of United States companies for alleged corruption overseas, and directed prosecutors to stop litigating fraud involving cryptocurrency. And again, involve this administration in cryptocurrency along with this Congress. This bill is just a handout to Trump's cronies who do not want to be charged with crimes like tax evasion as we pass a massive tax cut for the wealthy at the expense of the poor. It's a giveaway to corporate fat cats who want to line their pockets by polluting our air and our water to cut their costs. And if we hamstring the government's ability to charge these corporations for things like environmental crimes, big business will increase their profits by dumping more toxic waste into water, and Americans will pay with their health when these chemicals cause cancer, but you won't have a health system to get treated by because they're cutting Medicaid, they're cutting Medicare, and as a result of withdrawing that much money, trillions of dollars, $1.5 trillion from our healthcare system, hospitals and clinics and doctors' offices are going to be closing. So while these polluters are let off the hook criminally, the people will suffer. So let's look at this bill holistically. Let's look at it at this time when it's being introduced, and let's ask ourselves, why now? This is not a serious effort. I'm in favor of bipartisan criminal justice reform, but this is not it, and I urge my colleagues to oppose this bill, and with that, I yield back.
Thank you. Before we seek further recognition, I've been informed by the ranking member that if the proponent would work with them in good faith to go over cases that have already been decided, that are in case law, that may genuinely give an opportunity for a friendly amendment on the floor, that they'd be willing to bring this to a close for today. And and then we'd move the bill and move on. Would the gentleman opine on that, please?
Yeah, thank you. I'm going to let the last commentators.
It didn't happen, so please continue.
I'll pretend it didn't happen because it's so idiotic. But
That's just impossible to do at this point. The bell has already been rung, and I'm glad to have rung it, and I'll
The
continue
gentleman
to
is
ring it.
not recognized. Please continue.
Yeah, thank you. I would just point out to the ranking member, I think his concerns are assuaged on page 5 of the ANS, where it talks about any element of a covered offense to the extent that applying subsections B2 and C and C to such element would lessen the degree of mental culpability the government is required to prove with respect to that element under either a precedent of the Supreme Court of the United States or any other provision of this title or an act of Congress. I'm willing to work in good faith. I'm not sure, you're going to have to designate someone, Mr. Ranking Member, who can work in good faith, because the aspersions made about this bill, which were so absurd by the gentleman from Georgia, makes me call into question. I don't question you, Mr. Ranking Member, because I think you and I could work in good faith to see if there's an issue that we can resolve. But otherwise, I
thank the gentleman for just a moment. The ranking member.
So there's a Supreme Court case called United States versus Excitement Video, which found that there's a standard presumption in favor of a scienter requirement, which is a specific intent requirement, which is purposefulness, willfulness, knowledge, okay? Unless there's a contrary congressional intent that's been indicated. So that's, I think, the burden of the legislation, and I think it's the current law. The part that's making me nervous is congressional intent with respect to prior statutes. So say you're in a field where traditionally Congress has understood that the courts will treat it as a strict liability offense, say a dumping offense in the environmental field, but they don't specify it. So it's no longer in the language of the statute because the Congress has taken it for granted that the courts will interpret it this way. It seems to me that the bill at that point would override it because of the silence of the statute on the question. And that's why I'm going to want to look at it. And, you know, the chairman's very kind to suggest that maybe we could work it out. The problem is that because of the proliferation of statutes, we don't know exactly what we're talking about. And that's why I feel so strongly about the bipartisan bill we've got to count the crimes, to put them in front of us so we could check it out. But I'm certain at the end of the day, we're going to get to the same place on this.
I believe that's an offer by the ranking member to work directly between now and the time this bill comes to the floor. Does the gentleman agree to that?
I'm certainly willing to talk. And
I appreciate that. In that case, the question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Any opposed?
No.
In the opinion of the chair, the ayes have it, and the substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Any opposed?
No.
In the opinion of the chair, the ayes have it, and the bill is reported favorably to the House. Members will have...
I request a recorded vote, Mr. Chairman.
The ranking member requests a reported vote. The clerk will call the roll.
Mr. Jordan? Yes. Mr. Jordan votes yes. Mr. Issa?
Yes.
Mr. Issa votes yes. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Roy? Aye. Mr. Roy votes aye. Mr. Fitzgerald? Aye. Mr. Fitzgerald votes aye. Mr. Klein? Mr. Gooden? Mr. Van Drew? Yes. Mr. Van Drew votes yes. Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott?
Aye.
Mr. Knott votes aye. Mr. Harris? Aye. Mr. Harris votes aye. Mr. Onder? Aye. Mr. Onder votes aye. Mr. Schmidt?
Aye.
Mr. Schmidt votes aye. Mr. Gill? Aye. Mr. Gill votes aye. Mr. Baumgartner? Aye. Mr. Baumgartner votes aye. Mr. Raskin? No. Mr. Raskin votes no. Mr. Nadler? No. Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Ross? No. Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Moskowitz votes no. Mr. Goldman? Ms. Crockett? Ms. Jayapal, you are not recorded. Ms. Jayapal votes no. Mr. Gooden? Mr. Gooden votes yes.
Clerk will report.
Mr. Chairman, there are 15 ayes and 13 noes.
The amendment nature substitute is adopted. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 98, the Endless Criminal Statutes Act, for purpose of markup. I move that the committee reported favorably to the House. The clerk will report the bill.
H.R. 98.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Arizona, Mr. Biggs, for an opening statement.
Thank you, Mr. Chairman.